was going to say a couple things. It's Negative Land. We've been sued a few times for copyright infringement, and kind of there's of course, I could talk about that for hours and hours, that story, but it certainly created for a brief period of time a sort of a chilling effect on our work. We started thinking, well, gee, we need to start worrying about every single little move we make in making our art, our audio work, and our any films we make. And we really had to make a conscious decision, a conscious choice to say, well, no, I'm not going to sit around and try and be creative and worry about what a lawyer thinks about what I make. That's just absurd. It's ridiculous. And in fact, really what Negative Land has done is that, and Craig does this too, is that we, on the one hand, we're aware of these issues, we follow them. I mean, I'm now to the point where I've actually recently spoken in Washington, D.C. to all these people in Congress and senators and stuff about these issues. So we're dealing with it. But in our day-to-day lives as creative people, we really do operate as if these laws don't exist. We just ignore them. And I really encourage most people in this room to do that. Because realistically speaking, what are you doing with your work? Are you trying to get it on PBS? Well, then maybe you do need to really pay attention to this stuff and get your errors and omissions taken care of and all that. But if you're showing in some small gallery in Ann Arbor or putting things up on on a website or making your own little DVD or what have you, or in the case of Craig just self-distributes his own work, so does Negative Land. We're operating in a way that's so DIY that it's, for the most part, again, it becomes kind of a moot point. So that the question can be more about, not that you need to ask yourselves all the things that Larry just laid out. It's good to be aware of, but I also think that you could say, I don't really need to even worry about that. The way I'm operating and what I'm doing, I'm just going to try and make work. I think as a creative person, as an artist, your job is to make interesting work. That's your job.
And I'm curious, how many other artists in this room have felt themselves inhibited by copyright law? Perhaps they did not. Just by maybe a show of hands. I mean, have you felt chilled that you weren't going to engage in a certain art form because you felt that perhaps there was too much legal risk involved? And I think it's, I think Mark is right. I mean, I think there probably are instances when an artist can look at their particular situation and say to themselves, perhaps I'm just going to ignore, what a lawyer may tell me. But maybe there are other instances where, I think each artist has to judge for themselves what is the risk, what is the calculation, and what they're doing. It is unfortunate, though. I mean, Larry laid out the the 4-factor test, and what really could be simpler, right? It is unfortunate. I'm kidding there. It's unfortunate that we sort of make artists go through these hoops. They have to do this mental gymnastics to try to figure out whether or not their use is fair use, and they do this calculation. And I know as lawyers, it's very difficult for us to advise those artists. Do you want to talk a little bit about that, Larry?
Well, there's an old joke you've probably all heard, which is that the two things you don't want to watch being made are sausage or legislation. And what happened when Congress sat down in 1976 to write what became the new Copyright Act, the one we still operate under, is they said, well, gee, we got to write down some real clear rules about what fair use is. And the legislative process worked in its majestic way, and what happened is it became clear that they were never going to reach agreement in Congress on writing down a set of clear rules so that we could be sitting up here saying to you, use X percentage of somebody else's work for Y number of minutes and you're okay, and don't do that and you're not okay. That didn't happen. What happened instead is that the way they wrote this Fair Use Act, which is the one I was just quoting from, Section 107, is they said, we're just going to codify, we're going to write down into the legislation, in essence, a summary of all of the case law that's been evolving, in that case since 1909. So they basically tried to synthesize 100 or so important cases into the legislation, and we still have the same case-by-case analysis and problem that we had before the new act, which, by the way, took effect in 1978. So as a lawyer, what that means is that when I sit down in my office with a client who says, either, and I get both questions, one is somebody violating my rights by taking a piece of my song or my film? Or the other question is, what can I do to express myself as an artist using some other things that exist in the society and in the art? I have to run through with them a sort of excruciating analysis of what are the facts of what you're doing, including how willful are you about taking some other artist's work, and usurping their market? Have you asked for permission? The bottom line is you have to go through the analysis, and then you have to have a discussion about what is the real risk. Because at the end of the day, I think the kind of advice that any lawyer should be giving a client is not do this or don't do this or do that. I think what a lawyer's job is to help a client make in essence what the doctors, the physicians call informed consent. To say, here's the risk, let me help you assess the risk, and if you choose to take the risk, here are the consequences. If you choose to be chilled and not create a certain piece of work, you at least know that you don't have to be up at night worrying about, am I going to get sued? But again, I think as lawyers, what we do is try to counsel people on making an intelligent choice. And I, for one, don't think there's a right or a wrong answer to most of these issues.
Yeah, well, I think it's fantastic, and I appreciate the agency and the support for artists that lawyers give, but you're putting lawyers in the middle of the whole discussion again. And again, we're mostly artists here, and it's normative and it puts the artists in a defensive position. It's not necessarily that the law necessarily regulates industry, as you said a second ago. It could be that the arts push the law. I see it as more a proactive role. Just in negative land's a perfect example. What about prohibition? Well, that was overturned, not because of any legal things, because of the culture wanted to have access to alcohol. That's just one minute example out of many. So the point is that if you're constantly having to deal with a lawyer, it's effectively a kind of a chilling act. Why don't artists just regulate themselves? In other words, we don't really, sorry to say this, need you. We could just talk. we could just talk to the person who feels infringed, and I could establish an arrangement with that person, couldn't I?
Absolutely. In
Yeah.
fact, that's what the Constitution wants you to do, is for the individual artists who own the rights to talk. And if you go to Tom Paine and say, I want to make a movie based on your book, Mr. Paine, he can say, fine, do it.
The problem is that, the economic situation, it often isn't that easy. You can't always just go out and find the artist of the previous work. A lot of the clips that we just saw, I take it these are found footage, or maybe they're footage from...
Or you're using them in a way that's unflattering, so you're not,
Yeah, they're not going to give you a license.
It's impossible, you can't track down the owners even if you wanted to, and even if you asked them and you did have the money to pay them, they'd say, I don't like how you're using it. So there's too many, that doesn't always...
I think they would want to, first of all, they're probably dead, just so you know, and I don't think they'd want to prevent, they'd probably give their okay anyway, that's the way I feel about it. But it would be good if there was some kind of clearinghouse like that. I don't know what that would be, but they wouldn't have to exist within the law. It could be within an artist organization, see?
Right. Copyright law is in many ways one of the most inefficient property systems ever devised, and that is part of the problem. Is in many cases, I'm sure artists would clear the rights if there were a way to do that. That were cheaply, and it was cheap and it was efficient.